morning, good afternoon, good evening all. Welcome again to another episode of HR for Small Business. Today, as usual, I'm with Paul Maguire. Now, Paul Maguire is a Melbourne-based lawyer that specialises in employment issues and employment relations. Welcome, Paul.
Thanks, Kevin.
And Paul, what have you looking at discussing tonight?
Kevin, I thought we might cover a few topics, but certainly in today's episode, what I'd like to do is talk to the listeners about the changes to the Fair Work Act. It's called Secure Jobs, Better Pay. Now, the question is, what do these changes to Fair Work mean for small business? And in particular, there's so much in the legislation that's been introduced which is difficult to cover in one episode. But what I'll do is concentrate on the things that are going to have the greatest impact on small business.
Now, are we talking, Paul, from a national level or a state-based level?
No, it's a national level. The Fair Work Act applies to all employers, no matter whether you're a small, medium or large business. And the new legislation called Secure Jobs, Better Pay is relevant to small businesses wherever they operate in Australia. Okay, well, look, maybe I'll talk to you first about the areas that I'll cover. How about that?
Sounds good.
Okay, well, look, what I'll do is I'll cover several elements, which is prohibiting pay secrecy in contracts of employment, more flexible workplace rights for employees, prohibiting sexual harassment, and limiting the period of fixed-term contracts. All of those are things that I'm talking about, and they'll impact small business. First things first, disclosing pay information. Now, there's new rights that are applying from 7th of December last year. So they're already in law, Kevin. And this is important because one thing is outlawed, and that is that you must not advertise a job that indicates a wage or salary or form of remuneration which is less than the legal minimum amount under awards or the national minimum wage. Now, most of your listeners probably don't do that anyway, and hopefully they don't, but nevertheless, there is a law expressly prohibiting that. There's also more. The next thing is that employees are entitled to disclose, or choose if they may, not to disclose what their wages are, what their pay is. And employers must not prevent them from doing that.
Now, just before we move, can you give us a bit of an example exactly what that means for you? Typical small business, they might have 10 employees or even up to 50 employees. So just could you put that in some sort of context for us?
Well, the context is that the Fair Work Act gives employees lots of what we call workplace rights, okay? They have a right not to be discriminated against. They have a right to challenge or raise a dispute about how they're being treated and so on. Well, this is a new right, and that is the right that I can talk to my work colleagues and tell them what I'm paid. Many small businesses in particular may in fact have employment contracts or obligations on employees not to disclose what their wages or salary is paid to them. And the motivational reasons for that may be many and varied. But anyway, it's been a traditional or historical practice which is now outlawed. Okay, so if a new employment contract is entered into on or after 7th of December 2022, and mindful of the fact that we're now into 2023, if it has a pay secrecy term in it, that is, it says you must not disclose your wage or salary to anyone, then that's of no effect and it can't be enforced. And in fact, from 7th of June this year, there'll be some civil penalties that could be imposed on employers if they try to enforce those clauses. And that could cost employers thousands of dollars. So that's the first area that small business employers need to be mindful of. And we'll talk more about how you go about and deal with that, I think, at the conclusion. The next thing I wanted to cover was sexual harassment. Now, everyone knows you should not sexually harass your work colleagues or your staff. Everyone knows that. And it's in fact enshrined in federal legislation. It's enshrined in state and territory anti-discrimination laws. Well, the Australian government decided, well, let's enshrine that also and bolster that within the Fair Work Act as well. So there's now stronger laws prohibiting sexual harassment in the workplace. And importantly, Kevin, employers can be held what's called vicariously liable. In other words, they could be held liable for the actions of their employees. So if you've got employees who love to joke around or might be could be considered harassing another person, and it's of a sexual nature, unless you take particular preventative action, then you as the employer can be held liable for that person's action. This is pretty serious. So what that means, as we'll talk about at the end, one of the lessons is you need to get on top of this. You need to dust off your sexual harassment policies and induction and reinvigorate them in your workplaces. So sometimes, when someone says, can't you take a joke? Well, the answer is probably going to be no. I'd hate to think the workplace is not going to be a fun place, Kevin, but there are some no-go areas, and that's one of them as well.
And indeed, that has been definitely something that's been pushed across workplaces for not necessarily years, but decades now, that this message of sexual harassment is a no-go zone.
That's right.
So businesses and individuals, employees, subsequently have some sort of level of awareness that it's a no-go area.
That's true. That's true. The next area I just want to quickly cover is flexibility for employees. I've described it as more flexibility for employees, but less flexibility for employers. Okay? Now, there is a right under the National Employment Standard, Kevin, which is applicable whether your employees are covered by awards or not. And that is, all Australians have a right to request a flexible working arrangement if they meet certain criteria. And that criteria includes whether they're returning from parental leave, for example. So they have preschool age children, or they're caring for children who have a disability, or another member of the household who has a disability, or they have formal carer status. And it also relates to circumstances where there's family or domestic violence. Now, this sorts of requests for flexible arrangements could simply be, look, I'm coming back from parental leave. I don't want to leave baby in childcare 5 days a week. Can I go to part-time for, the next 12 months? That's a typical example.
Yes.
So there's a right to request that. And if you do receive a request of that nature, there's certain obligations you have to respond, and you have to respond in writing, and you have to do that within 21 days. So if you refuse that it's not possible to meet that obligation or that request, then you can only deny that or refuse that on what's called reasonable business grounds.
Okay, now tell us about that.
Yeah. Well, look, reasonable business grounds is the sort of things you would expect, and that is that too costly. There's no capacity to change the working arrangements of other employees, and that's very relevant to small business because you just got a small number of people. It might be impractical to change the working arrangements or to recruit new employees to accommodate that arrangement. In other words, if you went to 2 days per week, well, how are you going to fill the other 3 or the other 4, 6 or 7 day business? Or the new working arrangements would be likely to result in a significant loss in efficiency or productivity.
Okay.
Much more difficult to, I suppose, justify, but the onus will be on you as the employer to justify these business grounds for refusing that. But the answer to that, of course, is that if you've got a good relationship with employees, then you ought to take these requests seriously. And if you value them, then as far as you can, you ought to try and accommodate them. Now, also very quickly, Kevin, and I know I'm going through this fairly rapidly, and maybe into the future, depending upon listeners' interest, we may cover these things in more detail. Later in the year, the fixed term contracts, or what I like to call the maximum term contracts, where you say, look, you're employed for this period to cover this amount of work. And it might be 12 months, 2 years, it might be 3 years. You may have had a successful tender result. So you've got all this work that a major commercial operator or the government has granted you. Well, the legislation from 6th of December limit those maximum term contracts to no more than 2 years.
Okay, 6th of December 2023.
Three, that's correct, yeah. Now, there's a number of exemptions to that. But again, it's an area which is going to be slightly more complex because you as employers are going to have to become familiar with what your rights and obligations are. But the general rule will be is that the law does not want employers to engage people on short-term contracts.
Okay, and what would you deem to be short-term? What would be the time frame?
Well, it could be anything from 6 months. It could be anything up to 5 years.
Mm-hmm.
For example, if you get a successful tender, and there's many of our clients, as you might aware, Kevin, who've got contracts to deliver in the building and construction industry. They may, in fact, be working on major building sites. They may, in fact, be involved, particularly in civil construction, railways, roads, those sorts of things. Well, most of the work is tied to that particular contract. So therefore, they tie the individual staff's employment to that period. Now, those arrangements may be acceptable, but there's a little bit more we've got to work through that. But the starting rule is that it should only be for 2 years. And it is an area that's going to be a risk to employers. And I think we might provide some information on that a bit further down the track as we know a bit more. Okay. So exceptions, of course, will be as if you're an apprentice or if you are employed to cover someone, again, who was on leave, gone on long service leave or parental leave, that sort of thing. But as I said, we'll cover that in future podcasts, I think, to keep people up.
Yeah, without going too much off track. So I'm thinking of the listeners and their small business. And let's take hypothetically a printing facility. They've got 10 employees. And the terms of employment contract agreement, what would you deem too short, 6 months to 2 years, or is that 2 years?
No, you can do anything within that 2 years. Okay. You could do it for 1 month. You could do it for 1 week if you felt inclined. But 2 years is the maximum. Okay. So if you can do it within 2 years, and certainly most small businesses will know whether the person is capable of performing the particular role probably within the first few weeks or certainly months, depending upon the nature of the role anyway, to whether they're suitable. But the use of fixed-term contracts really should be directly related to the nature of the work that they're performing. Is the work, the project, of a fixed-term nature in itself?
Yes.
And if that's the case, then use fixed-term. It's still important to do that because there is a risk of having to pay redundancy if you roll over these contracts year after year after year after year. So, and you need to get advice on that. So maybe I should just move on to maybe some lessons now. Okay. If we finished up with some lessons and then where to get further information or how to move from there. Well, look, it seems to me the first thing you need to do is you go back and have a look. If you have written contracts of employment, open them up and have a look whether you have pay secrecy clauses. If you have, then any future employment contracts, delete them. Okay? Get rid of them. Secondly, we need to dust off the induction and policies on sexual harassment. You may as well add bullying, workplace bullying in there as well. I know into the future podcast, Kevin, I will need to cover the anti-discrimination laws and we'll pick this up in more detail. Sure. But you do need to ensure that employees are very clear about what their obligations are around sexual harassment. Flexible work arrangements, become familiar with it. Don't just say no.
And Paul, on that, and you did touch on it, but I think it's worth revisiting. Employees will have the right to ask, but as an employee, you don't have the obligation to provide that request, provided you can justify under the list of items you listed.
Yeah, reasonable business ground. Yeah, you're right. The right is a right to request. It's not a right to actually have the flexible arrangement. So it is a discussion that has to happen. And the grounds upon which they can be agreed or disagreed will be limited around these reasonable business grounds. And then finally, we need to consider alternatives to fixed-term contracts or retain them or contain them within 2 years wherever